Good afternoon. We apologise for the few minutes delay. I'm Max Gordon, and not quite with me just yet is Matthew Tim. Matthew has unfortunately been delayed in court this afternoon. He is on his way back and will be joining me when he is able. Today's webinar is Awaab's Law and Fitness for Human Habitation, the same but different. As it sounds, we're of course dealing with the changes that have come from new regulations coming into force this week as of the 27th of October. At recording, we are at the 29th of October. And we'll be doing a summary of the position beforehand, looking at what changes there have been and how significant those changes are, how the process can be set out for the social housing landlords and tenants, and then a sum up. And hopefully at that point, I'll be able to have a discussion with Matthew when he joins us about what we think the significant points are as a takeaway. Any questions as we go along can please be put in the Q&A box, and if we have the time and we're able to, we'll address them as we go. As I'm currently on my own, I'll do my best to try and field them if I can see them coming through. If you are joining us through the recording, please send any questions to events@42br.com and we will respond to them as we're able. And I'll point out now that an email with the slides will be circulated following this event. So, Awaab's Law, named after the very sad matter involving Awaab Ishaq. Awaab was a 2-year-old boy from Rochdale who died in 2020. And following his death, the coroner found that it followed an illness, which was the result of respiratory issues from being in his parents' housing association home that had been subject of mold and damp. His parents had reported those issues, but unfortunately his landlord had not taken steps to address them adequately or in time. Now, the issue of hazards is, of course, nothing necessarily new in social housing or housing. But this landmark case brought forth the regulations of 2025, and they require social landlords, so it is social housing that we are focusing on here, to fix reported damp, mold, and emergency repairs. And the key takeaway, as was come from the starting point, and we'll circle back round to the significant changes that have occurred, is the strict timeframes, in my view. And it's the formality, it's formalizing a process that perhaps has already been in existence, but creating the timescales for landlords to respond is a key factor that we'll be looking at. So as a quick recap, before the 27th of October, just the other day, where was the law then? Well, we were already aware and dealing with matters of fitness for human habitation. We have the implied covenant under Section 9A of Landlord Tenant Act 1985, that's fitness for habitation. The prescribed hazards that have to be acknowledged under Section 10, and of course defined under the Housing Act 2004. As a slight whistle-stop reminder, the statutory provisions we're looking at there. So the first is the implied covenant, fitness for human habitation. Now, as a reminder, that property needs to be reasonable to be lived in, effectively. So you can have cases, and I certainly see them often disputed in court, where there are findings of potential hazards or hazards identified in the property. Now, that does not necessarily mean that they are unfit for habitation. They have to be considered on a fact and degree case by case. But it is that it is fit for human habitation, and it will remain so during the term of the lease. The prescribed hazards as considered and set in Section 10, and the liabilities for, of course, repair, stability, freedom from damp, ventilation. These are all very common issues that we're already familiar with addressing in disrepair matters. When we refer to prescribed hazards, and the word hazard, sometimes misused, I've seen in certain expert reports, but it is given a particular definition. And of course, that's the definition that we take from the Housing Act 2004. And what we are referring to Normally, you'll often see the references to category 1 and category 2 as to how severe the hazard is. Now, hazard really means any risk of harm to health or safety of an occupier. So it is not just tenants, it's occupiers as well. And that can arise from deficiencies. Now, importantly, matters of fitness for habitation, of course, can be different to matters of Section 11 disrepair. You don't necessarily have to have disrepair for there to be a hazard that the landlord needs to take action on. The prescribed hazards, well, there is a list, and it includes things that probably won't come as much of a surprise for those reminding yourselves now. Damp and mold is already on there. It is already something that is of course concern, and that's something that landlords should be addressing. Other matters, excess cold, electrical hazards, issues with stairs, or really all matters that you see listed there probably won't come as much of a surprise. The one that does just stand out on that list for me is number 11, crowding and space, because overcrowding is not included in the new regulations, as we'll note shortly. So Awaab's law and the 2025 regulations has inserted a new Section 10A into the Landlord and Tenants Act 1985, a new implied covenant. Includes reference to the prescribed hazards, and then there is reference to the regulations which provide certain things regarding timescales and reporting as well, which would be another key aspect that landlords need to be aware of. So again, you'll be able to look this up yourself and the slides will be circulated, but here is an extract that Matthew very kindly added into the slides for us of 10A. So of course, the specifics we're dealing with dwelling in England, of course, dwelling, very broad definition, but as already stated, it is social housing leases we're dealing with that have Section 9A applying or would apply to the lease if the provisions of Section 9B did not exist. There is implied into the lease again that they will comply with all the prescribed requirements. And again, it's all about taking action on the prescribed hazards. Of course, where action wasn't taken before, the dire consequences that have seen can occur. And that's really the focus of the 2025 regulations. It is creating this framework for timescales, for reporting, and for what then happens next. There will be, of course, a breach of covenant if that is not complied with. And a matter that is a phrase being raised more and more, I'm seeing in statutory drafting at the moment, is also a matter of using all reasonable endeavours to avoid the breach. Now, this will come under an exceptions point we'll be coming to. And what is all reasonable endeavours, I think, will likely be a matter for dispute in certain cases. But as it sounds, a landlord does need to be taking sort of active steps and really exhausting the reasonable efforts that are available to them. That will particularly be a case, for example, where a landlord may need permission to undertake certain work. Now, the reasonable endeavours point will largely be focused there in getting that permission, the steps taken to do so. So as we just mentioned, some exceptions. So firstly, under the reasonable endeavours point, and I think likely, as I say, that's going to come under points where, for example, permission might be needed to undertake certain work. Now, the relevant hazard is also a particular point because, of course, if it is wholly or mainly attributable to a lessee's breach, so their conduct, for example, or they have acted in some way that is in breach of their covenants, then that is an exception under the regulations. And similarly, so if it is to the premises has not been used in a tenant-like manner, for example, that comes under the exceptions, or to rebuild and reinstate from matters of destruction by damage by fire, storm, flood, or other. And the point is to keep in repair or maintain anything which lessee is entitled to remove from the dwelling. That's under Regulation 4 as well. Now, there's a three-phase implementation. So from the starting point from just the other day, 27th of October, it's all emergency hazards, as I know, apart from overcrowding, are included. and all significant hazards of damp and mold. Now, there's some key words here that we're going to come to on the next slide for some further breakdown. In 2026, the significant risk of harm hazards, so excess cold, heat, falls associated with bars, they are then being added in. So are electrical hazards and fire hazards, for example. And then it is in 2027 phase of implementation, again, apart from overcrowding, that the further remaining hazards are going to be considered and added in. So the immediate consideration for tenants and particularly for landlords of social housing looking to take action that they must, of course, we're looking at the significant hazards and the emergency hazards. Those are the ones that are pressing immediately. And here he is.
Fresh report.
Thank you for joining us. We've done the summary of where we were before. So saying, of course, prescribed hazards, nothing new.
Yeah.
We've just been touching over the 3-phase implementation.
Yeah.
And I was just saying how, of course, the focus at the moment is regarding emergency and significance. Of course, we've got some key words there. So just coming to the breakdown of some of those keywords to be considered. So key terms, a competent investigator. So, of course, a big part of some of the phases of action we're going to come is about taking investigatory action and then also compiling reports. And that needs to be by somebody in the reasonable opinion of the lessor who has the skills and experience necessary to determine whether the home is affected by a significant or emergency hazard. There's no particular definition there. I certainly see in some disrepair cases already there is sometimes a dispute as to whether a individual who's compiled a report has the qualifications to do so, but I don't think that it's necessarily that high of a threshold in this. It's the reasonable opinion as just if they're going to have the relative experience. Do you like to take us with emergency hazard, Matthew? Joining in.
Emergency hazard, the way that's been described is something that poses an imminent or significant risk of harm to the health or safety of an occupier of the home. Whilst it sounds difficult, really what it's getting at is with these new regulations, it's all about, well, is a hazard an emergency hazard or is it a significant hazard? And so here you're really looking at what we'll come to is this 24-hour period to get emergency works done. And so it's that imminent and significant risk of harm is the way the regulations have tried to define it. And so just for your layperson, that's how I thought about it in my head. Is it something needs to be done within 24 hours or less? That's the threshold, but we'll go on to see how the courts interpret imminent and significant risk of harm.
Yes, and be having a think now for yourselves. I do have a slide coming up of some suggested examples of what we would think would come under emergency. But for my part, when I opened, I was talking, of course, from our title, we said discussing how much change is there. Some of these matters, of course, if you have something already before the 27th of October, which would seem an emergency, something that you really think your landlord should come out and sort out straight away, that, in my mind, is the sort of things that we're talking about.
Yeah, exactly.
So, of course, from defining emergency hazard, we have to consider what is imminent and significant risk of harm. So, as Matthew said, this is the risk of harm to an occupier that you would really take reasonable steps, or a reasonable lessor would take steps to make safe within 24 hours. So we'll have some further examples in a moment, be thinking of what pops into your mind there.
And again, significant hazard, it's slightly less severe as the emergency hazard. So it's a significant risk of harm to the health or safety of an occupier of the home. And again, the way I've gone through that in my mind is looking at the definition of significant risk of harm, which is anything that's more than 24 hours. So it's still significant, but it doesn't require immediate steps within a 24-hour period. And so when we look at some examples, some quite obviously fall within that 24 hours, some maybe over. It's that grey area in between that's going to be quite difficult.
But I think the use of the word significant, it implements a point of urgency, doesn't it? It's that is still an important point. So the steps that landlords may need to take. And now the order of these, I was mulling over in my mind, because you may think, well, don't you need to investigate first to then categorize? But the categorization of the hazard, as we've already covered, is very important, because that affects your timeline that you need to comply with. So I am, practically speaking, in my mind, I think there's going to have to be an initial, sort of gut instincts, bit of common sense take on where does it fall? Is it significant? Is it emergency? Or is it actually outside of the scope, at least at present? And we've got that scope extending, of course, as we've already gone over on the implementation. So that is what we're suggesting as step one. So the emergency hazard examples we were hinting towards: gas leaks.
Yeah,
very obvious. Something that is so urgent, anybody would report a gas leak and, of course, expect it to be acted upon very quickly. Broken boiler, particularly as I look out the window, and it is now, of course, clocks have changed, it's dark, it's getting cold. A lack of heating or hot water in a property is, of course, likely to be very urgent. Similarly, total loss of water supply, electrical hazards. And I think perhaps it would depend on the extent of the hazard, how dangerous it is. Again, the word significant water leaks, a small bit of damp that is perhaps being observed, which of course is going to need to be addressed. Perhaps not as urgent, but something that really presents risk and danger. And then, of course, security. If you can't be secure in your home, your external door or external windows, particularly if it could allow access to anybody walking by, is likely to be involved. And indeed, if we've already got the point of emergency, or then significant, and significant being the risk of damp and mold. But if it is that significant and it is that serious, I think damp and mold could still, of course, come into play. And of course, if you've got some water leak and that's potentially affecting the structural aspect, the safety, if ceiling might fall in, something like that.
Yeah, and I suppose the thing to think with all of these is that if in that initial assessment there's a potential for it to be an emergency, that's the shorter timeline, and so you have to stick to that in order to protect yourself.
Act out of caution.
Yeah.
If you're not sure.
You're not sure,
yeah,
that
sure.
Out of caution, treat it as an emergency. Whereas if you are using that 24 hours distinction or not, that's if it does more comfortably fit within a significant hazard, then you can go down this route that we're about to set out. But it's difficult, isn't it? 24 hours is a very short amount of time to deal with a problem, and so
it is. And just reflecting on the difficulties some social landlords have with contractors and the availability of work, I think it is going to present a challenge. It's going to be a challenge that is obviously serious and it needs to be addressed, but it's a real matter of now skates on and make sure you're getting the infrastructure in place to step up and answer the call. So if you have the emergency position, obviously we're talking about that 24 hours. And if the investigation confirms the emergency hazard, then 24 hours from becoming aware of the hazard is where those works really need to be done. If it is significant, there is obviously urgency, but less urgency, more of a timescale. So the investigation, you then to have within 10 working days of becoming aware. The investigation does not necessarily need to be physical. It could be a desktop investigation, but if a physical inspection is required, that can, for significant, not emergency, include an extension for a period of 10 working days. And I do know, obviously, apart from the 24 hours, I think I'm right in saying that all the day provisions in the regulations, they are working days, aren't they?
Yeah.
Yeah.
And so just to work through the top example, what might happen is a tenant might complain of damp or mold and send in pictures. And so that investigation could go on remotely within 10 working days. But if the tenant on day 9 turns around and says, no, I want you to come and physically look at my living room where you'll see this damp and mold for yourself, there's then an extended further period. So that would be 19 working days altogether. And so that's how I see those provisions working. And
I can see this sort of being, not a fallback, but people, particularly if you're invited for a desktop review, for example, this point of if further investigation is required as soon as reasonably practicable. Now, not all matters are going to be able to be exposed or investigated straight away. I'm not a surveyor, I'm not an expert, but I can certainly see the practicalities of that, and you see reference to that in various expert reports. But as soon as reasonably practicable, I don't think it can be expected to allow things to be kicked off into the long grass a bit. And we'll come to why that is, because there are then the provisions as to the timing of the reports that need to be produced as well.
And importantly, that applies to both the significant and the emergency hazards. So if both of those need further investigation, that's when that test of as soon as reasonably practical comes in. But you're right, the time frames still carry on and different obligations come up, which we'll get onto in a minute.
So a quick recap again, available of course online, and our slides will be coming out, but this is where we're taking the words from. So regulation 3, defining significant hazard, significant risk of harm, as we've just gone through, emergency hazard, and then the imminent and significant risk of harm, and those timelines there. So whether it's within 24 hours or urgent, but not within 24 hours. So step 3 in my mind was the report, because, and again, this will depend on case to case, because you may, of course, need to go in and immediately be doing the works. And if you do the works immediately and it's within 3 days, you don't necessarily need a report, because, of course, you've completed everything. So as we say on the first point there, unless the work's been carried out within 3 working days after the investigation, you must provide a report. And I think that's one of the key changes here.
It is.
And it is a lot of keeping tenants informed, just keeping the information coming, and it carries on throughout the process. Specified information?
Yeah, so there it needs to set out, no matter which the investigation was. So that was what we were looking at before, that if it's an emergency investigation, that's within 24 hours. If it's standard, it's 10 working days. Or if it's renewed, that's just that further information was required. Then it needs to identify, well, is there a hazard, and what is that hazard? Is it within the significant or the emergency? And once the hazard has been identified, set out what that is. And then from there, it should also set out what further actions are required. So that will be the works, the timescales, and all of those things. And if there is no further action required, explain the reasons why, that perhaps under further investigation there wasn't a problem with the boiler and it was found it was something else, and now that's being fixed. That might be how that comes up.
I think that's perhaps a key factor. I think you sometimes see disputes as to, I'm thinking like, more standard disrepair cases, and you have disputes on what work was or was not done. Did it resolve the issue? So, and then there is sometimes a little bit of there can be a bit of a gap in the evidence there of, how that was documented. Often not, you have photographs, but there is a little bit more informality in the reporting, whereas this is obviously creating a structure for setting out exactly the information that is needed, and very importantly, setting out reasons why. And again, I thought this was interesting, the information about how the lessee may contact the lessor. Now, I mean, almost that is, of course, there's already provisions of that. I think, Section 48 notice and things like that. But it clearly needs to create a point of contact, I think, really for this particular cause and this particular reason. So, of course, then you come to the actual works. So if the investigation, within those 10 working days, confirms significant hazard, then the works must be complete within the 5 working days of concluding the investigation. And there is a point here of whether there's supplementary work. So you may have initial works which can address a hazard and make safe, but there may be further supplementary works which are required, which can't be started in that period, but for example, may prevent the hazard from recurring. And they must be started as soon as reasonably practicable. But again, at this point, it has been codified. You can't just let it drift off into the distance and into the mist. There is a backstop of it must be begun within 12 weeks of the investigation concluding.
And the way I thought through this is, say with damp and mold, the immediate action within the 5 working days might be to wipe down and clear the damp and mold. But then some supplementary work to prevent it from reoccurring might be painting a mold wash on the walls or that sort, or something along those lines. And so
finding the source of damp behind a wall.
Exactly.
Yeah.
And so it does go slightly further in that you really have to think about, well, there weren't any works to prevent the hazard from reoccurring, and that seems to be a slight step more required by the regulations compared to, say, just your ordinary disrepair where you have to make good. But that was my reading of it. But like you said, there's strict timelines for this, and so you've got 5 working days to do the actual safety works to resolve the issue, and anything after that must be started within those 12 weeks.
And there may, of course, be reasons for not completing the works within the 5 days. So let's have a think of those. I already raised, I think, just before you joined us, one of the exceptions point, I think, and the all reasonable endeavours. I think that's going to really apply where the works in question, you're going to need permission from another party. Perhaps it's a superior landlord. Perhaps you need access to a different flat not owned by the landlord, of course, has another occupier in it. You need to get permission to access to undertake the works, things like that. Or, as we've set out, the investigation that needs to happen, subsequent investigation might find that there was no significant or emergency hazard. But again, that's going to need to be recorded and explained very clearly. The point we've touched on, so the property must be kept safe. And then there may be this point of supplemental works to prevent recurrence, and they must be commenced either within the 5 working days or with that 12-week backstop. This work must then be completed. So, of course, that is the starting point, but then completed within a reasonable period. Again, I think that's going to be an area of litigation. It's obviously going to be factor and degree, the amount of the works, the parts required. But again, I think what is reasonable will be reflective of the type of issue you're dealing with, and effectively how long can it possibly be expected to reasonably be in that position. Now, there may be a point where you actually do have to decant now, and that's a more positive action than we've seen before. And that's one of the next steps we're coming to. And again, the tenant must be kept updated at all times.
Yeah, and so you're right, this is really a new obligation that the landlord must offer suitable alternative accommodation, so temporary accommodation while works are ongoing to the subject property. And this is an obligation that's on the landlord, so they have to offer this, and it's a requirement. And so it arises in 2 ways. Firstly, for the significant hazard. So if within those initial 5 working days to complete the works, they can't be completed, then the landlord must offer that temporary accommodation until such time that the significant hazard is fully resolved. In terms of the emergency hazard, that's an even shorter period. So if the property can't be made safe within 24 hours, so if you get to hour 25 and your boiler is still broken, then the landlord must offer that temporary accommodation until safety works are completed. And in the regulations, it sets out that accommodation has to be provided at no cost, and it's to include the tenant's household. So that includes any family member who normally resides with the tenant. And in the regulations, it makes provision for children. I think it's if a child stays with you one night of the week and they're your caring responsibilities, then they're part of your household. And so that's in my view, that's almost a new strong obligation on landlords that sometimes we see in disrepair decants are offered.
Yeah, I was about to say decanting is not a new thing, but again, I think the thing we're pressing here is I think the purpose of the regulations is to formalise these matters and put them in a time frame. Now, it may be you get points where the offer of alternative accommodation isn't necessarily accepted. And then there are some requirements there as well, which we'll just be coming on to. So safety advice to occupiers. So where the landlord will believe that a tenant or occupier will be in occupation after the initial remediation period, or it won't be wholly unoccupied during the rehousing period. So the period the landlord considers and must offer that alternative accommodation, but the property hasn't been able to be made safe in that period, then they must give the tenant information. So that is where the landlord thinks that action by the occupier can sufficiently mitigate risk of harm, set that out. Now, I was trying to think of examples of this, and on particularly emergency works, I'm struggling, to be honest, off the top of my head to think. I mean, when we talk about tenant conduct and things that can help, it's about, you often see things in expert reports with damp and mold, and it's all about ventilating, isn't it? Keeping the property clean. I can't see that that's going to be the type of thing here, but there's going to have to be some thought if there are steps. And again, I think this will be relevant where you've got somebody with the relevant expertise investigating and commenting on matters. They can offer, of course, their insight. If such actions can't sufficiently mitigate the risk of harm, information about any action that can reasonably be taken or avoided to at least reduce that risk of harm. So if there is, I suppose there's then a separate issue where you might then get disputes over, is it suitable as alternative accommodation? The relevance of that in other areas of housing, people will be very familiar with those sorts of disputes, and it'll be about what is available, how long it needs to be, obviously the number of occupiers. But setting that aside, if you have this knowledge where there is going to be somebody in occupation in this period where the concern lies, that's not the end of it. You need to then provide this information. And again, I think it's another formal, getting it in a report so you have it in writing, so there can be then no dispute that these regulations haven't been followed.
You're right that most often this information probably is provided, but it's formalizing it and almost showing your working so that if and when a case arises, it's very clear that that advice has been given to the occupiers that remain in the property. And
so after that full process, you get to step 5, completion of the works. So the hazard is resolved, safety works are completed, and then, of course, at that point, the obligation to provide alternative accommodation ends. And now this is Matthew's doing, very impressed.
Well, no, it's not. So I found this, that the government on Monday produced guidance, and this is diagram 1 from that guidance. I think it's called Social Landlords guidance, that I didn't dare try and create something as colourful and with as many arrows as this.
No, but we are very, always grateful for the visual aids and like say, a bit of colour to liven up a topic.
And so moving from left to right, you have different steps there. So it's what we mentioned before. You need to identify the hazard. So is it a significant hazard? And if below, it becomes an emergency hazard, that obviously sets it off on a different path, or it's totally outside the scope of our Awaab's law, and therefore it goes to the green box. And so just working through the significant hazard, once you've identified it's a significant hazard, you need to investigate within 10 working days. Thereafter, you need to provide the reports within 3 working days, and to have made safe and begun any preventative works within the 5 working days of the investigation concluding. And any further work is that as soon as reasonably practicable and within 12 weeks, if not suitable, if it can't be done within the 5 working days, suitable alternative accommodation needs to be provided. And then you can see the same there for the emergency hazard, that it's just a slightly shortened timetable of the investigation and action within 24 hours. And if it can't be resolved, temporary accommodation. And so that's the crux really of Awaab's law. What's the hazard? And then from there you can work out what track it needs to go on. But that's the crucial first step, to know what deadlines and how long you have to take the following steps.
I think I just saw a question pop up in the corner, which are then being filtered across to us. But I think someone was asking about the counting of the days and the weeks. So that 12-week backstop, that does include the initial 5 days. It's not 12 weeks and 5 days. So it's 12 weeks of the completion of the investigation, I think was the question. Apologies if I read that too quickly and wrong, but we'll cover it at the end if we can. One point I think I've just seen come across that this is relevant is, of course, some people will be considering the transitional period. So what if you're aware of a matter from before this week, before just the other day, 27th of October? What happens then? Well, it's not then just immediately, for example, 3 days running from the 27th of October, or the timeline starting from there. It will be the first report after or since the 27th of October. Now, that will include if there is a report of material change. So it could be something you're already aware of, and it is then either reported again, or if it is reported to have changed in some way, that's going to be the first report for the purposes of the regulations. That's with emergency and with the standard investigation as well. It applies the same.
And so I can imagine that there will be an influx this week from people suffering with damp and mold and/or emergency hazards, making the report so that it's clear that that first report has been made in order to get the ball rolling.
Yeah. So the question I've just had come across is, I think this is interesting. How do we deal with Section 11 claims alleging damp and mold? Can this be used as notice? Can this be the first report? So the LA would be in breach if they don't meet the strict time frame. Often letters of claim have some allegation of damp and mold. So we're unsure how to protect the client without overwhelming them.
And so this comes back to, is it those three things when first considering Awaab's law? Is it a significant hazard? Is it an emergency hazard, or is it outside the scope? And so look at the damp and mold. It's most likely not an emergency hazard unless it's drastically severe that it needs imminent works.
Yeah.
But if there's a significant hazard, and by that we mean a significant risk of harm, and that goes on to say reasonable steps within a period that's longer than 24 hours, but still needs to be done not imminently, but within a reasonable time. That's what you're looking at. And so it's going to be difficult, because there will be thinking of a Venn diagram of one that it's a significant hazard and one where it's Section 11 damp and mold. But again, out of caution, I think you've got to consider, does it meet the test of a significant risk of harm to the occupier? And if it does, Awaab's law applies.
Yeah, and it's going to be extent and degree, isn't it? In a similar way, a small bit of mold on the very corner of a bathroom.
Yeah.
And then you see an allegation of unfit for human habitation.
Yeah.
I've never seen that succeed in court. Obviously, what is fit for human habitation is a matter under Section 9A, is a matter for the courts to determine. You often get expert reports commenting on the same, and it may raise that this is a breach in their view, or a potential breach. But the judge reviews the evidence. They obviously hear from the tenant. They see the pictures more often, importantly, than anything else. And if you've got some extensive mold, well, obviously that is a significant problem. That could be a real risk to your health and harm. But if it's very small, very minor, it could just be wiped off almost, I think. We don't want to downplay the seriousness, of course, of what this can be. But unfortunately, it's going to be applying common sense, and it's going to be applying on fact and degree of each case.
And you're right that in those initial pre-action stages, the parties should be hopefully agreeing as a single joint expert who then will be asked to look at these things. And so if the expert is saying the damp and mold is a hazard and that it's in the realm of unfitness, that would immediately place me thinking about Awaab's law and the timescales, even if it's not specifically mentioned.
I mean, we talked about what order do you place these things, and I'm thinking back to the diagram that you extracted from the Gov website, and there was that reference to that initial determination, and I think that's perhaps important. And if there is any doubt, like you say, the inspection doesn't have to be physical, or not necessarily physical straight away. Request a photo.
Yeah.
Somebody saying, "Oh, I'm really concerned there's a hazard of mold or damp." Request a photo or a video that can be looked at to assist maybe that initial consideration. Maybe a practical step to consider.
And then we move on to the question of, I've already started seeing some pleadings of Awaab's law, knowing that the delay in getting a hearing means that
I haven't seen one yet.
It will be enforced by the time the hearing comes around. But how is the court going to assess breaches of the implied covenant under Awaab's law. And at the minute, it's not clear, but we have the general principles from disrepair, which most of you will be used to, in terms of the global assessment, the notional reduction in rent, or a combination of both. And the majority of the time these days, I see a notional reduction in rent, and that's the primary objective there, set out at the bottom, that it's not to punish the landlord, but so far as money can, to restore the tenant to the position he or she would have been in had there been no breach. So those general principles will apply. But if we go on to the next slide, it's then a question of, well, how exactly and what numbers are we talking? And so the way fitness for human habitation has developed in recent years is one of the first cases to award 100% rent reduction. So that's where the court finds that a property is unfit for human habitation based on one of the hazards, including damp and mold, that for the period it was unfit, the tenant should be awarded compensation, which is 100%.
In my mind, I wonder if that is a bit of a marker, really, for landlords to have in their mind, because it's really a message of that tenant should have been decanted.
Yeah,
they should have been provided the alternative accommodation.
Exactly.
So that's what's being formalised here. So I think that is the principle, but I do think I think the way the wording the regulations, of course, you've got the different degrees. I don't think you can have in your mind, well, it has to reach the point of unfitness for habitation.
No.
At all. I think it is, but it is more nuanced than that. It's more refined.
Exactly, and even that. So that was a county court judgment, and there's been subsequent cases that have considered unfitness and only awarding 90%, which you can see there. But what I envisage is that there will be that distinction between an emergency hazard and a significant hazard. That an emergency hazard, to my mind, goes much more to the similar principles as fitness for human habitation, that if you get over that 24-hour period and you're in the realm of needing to decant, it should be that 100%. But will it be slightly lesser for a significant hazard? It's difficult to know, and it's going to depend on the facts and the degree of the hazard. And probably because it's compensation, the actual tenant themselves, have they got medical conditions? How have they suffered? All of those sorts of things. And I suspect that judges who will be dealing with this for the first time as it comes up may just use the ordinary principles under disrepair and or unfitness first before really having to make a decision on how to award compensation under this new law, if the route is open to them to say the property is unfit for human habitation and I therefore award 100%. So it's kind of time will tell, isn't it?
It is. I'm not. Yeah, I have to say I'm not sure how, because obviously there's so many different ways damages are considered now. Is a breach of these I'm not sure how it's going to be applied. And I think somebody just asked a question I saw flash up about what happens during decant during the alternative accommodation. Well, if you complied with the regulation in that sense, then you're not in breach there. But there are already authorities, of course, where, for example, if you have to decant to do repair work, that doesn't necessarily stop damages. It can assist, but there is a loss of amenity to somebody not being in their own home. So it prevents a breach of the regulations, but I wouldn't count on it being a complete stop to for example, considerations of damages.
Exactly, and dealing with that issue daily in courts, I get such a different perspective each time on different judges.
Yeah, absolutely.
Some say they're not in their property, but that's the one that they've demised under the tenancy 100%. Others will say, well, they're getting some benefits of the temporary accommodation, but not the benefit of their tenancy. And so it's a lesser percentage. But
I've seen some unusual cases where someone then doesn't want to leave their decant property.
Yeah.
So they're obviously not really losing any amenity there because they'd rather be where they've been decanted to. I've just seen.
But this is the crucial thing of what has changed. Well, there's clear timelines and timescales for completing works, investigations, reporting based on the hazards. And you're right, it's formality and structure that some of these things may have been done already, but now it's very clear and sets out exactly what is expected and when. That for anyone on the defendant side dealing with this, you almost need two sort of flow charts, depending whether it's significant or emergency, and to be making sure that that's strictly followed.
Yeah, and I think, it's the format, and like the reporting is obviously part of that structure. That's almost something that you would like to see happening already. And sometimes, it's done very well and very clearly, and sometimes it's not. Now it has to be.
Yeah.
Now it absolutely needs to be. And I think I did just see a question. No, so I thought I saw a question about reporting. I can't see it there.
And I think if you're on the claimant side and thinking about particulars of claim, it'll be really important to set it out clearly that so often just see fitness for human habitation thrown in as an alternative without really reference to the hazards. That if you're claiming breach of Awaab's law, you very clearly need to set out, well, what is the hazard we're dealing with? Is it significant? Is it an emergency? And then what facts have happened since to say that the landlord is in breach of their obligations? It can't simply be that damp and mold was found in the living room and therefore the landlord's in breach of Section 11, Section 9A or Section 10A.
I just point, as you phrase it that way, you often see a pleading which is words to the effect of, well, the landlord's been put on notice. So you've got no, I don't think that, to be honest, very rarely flies anyway, in my experience. It's got to be more particular. And I think here, the first report and then when and how the breaches of the regulations have occurred and Section 10A, I think has got to be actually pleaded. It's got to be specifically noted.
Yeah, I agree.
So what has changed? So we've got the points there. Hazards. Landlords needing to take action in these points. That is nothing new.
No.
But it is now within a structure that everybody needs to get on board with and be actioning. So I've seen a couple of questions as we approach the end of an hour. We appreciate you sticking with us. Let's see. I think there was something. Oh, yes, here we go. What happens if a tenant refuses alternative accommodation? Say they say it's not in the right place for family, etc. What is the landlord's obligation? Does the landlord have an obligation to offer alternative accommodation in certain areas, for example? Well, that's the reasonable alternative. I think it would be reason. You get this in various different cases in homelessness applications and alike, and I think it's going to be a similar yardstick. Is it a reasonable alternative? Now, it's not going to necessarily be exactly ideal. How reasonable it is, again, if it's only going to be needed for a very short period, perhaps I think there's a little bit more wiggle room and a bit more leeway. But yes, if you are, on one side of London and the offer is completely on the other side, well, then that's not going to be a reasonable alternative. I think that's going to be plain to be seen.
And the important thing, it has to be suitable for both the tenant and their household. And so, say if you had a tenant's partner who was disabled and in a wheelchair, despite the fact it's not the actual tenant, by offering them a temporary hotel that's on the 4th floor without a lift, that's not going to be suitable, and that's an obvious and clear cut. But regard is going to have to be had to both the tenant and their household to determine what's suitable. And it's a question of facts and degree, isn't it, of how far it should be. Quite often see things about if people have young children, how far it is from their schools and all of that. So it's just going to be one of those ones that will depend on the particular circumstances, but it's important to think about the household rather than just the tenant in question.
It's an interesting point. So I'm saying could it affect or will it affect housing condition protocol? Landlords will have no choice but to fix any significant hazard and will not be able to preserve evidence for the claimant's expert or a single joint expert. I think perhaps, in my view, that might be, I think it's missing the point. Because if the work is done in the time frame, well, there's not really going to be any loss. There's not going to be a claim. I think that's the point. It's if you're after that breach. I think the whole intention and the wording is, like we said, it's the formality and the time scales and the reporting. Get the work done within that reasonable period. Make the property safe. If it can't all be done straight away, well, then there's the slightly further period for the investigation, and then the work to be completed following the end of that, begun after the investigation. The work then doesn't have to be obviously completed in that time frame, but within a reasonable time frame. So you're not going to be able to start it and then leave it for a number of months. I think there isn't a point of obviously a duty to repair, even before the regulations is always ongoing.
Yeah.
So you get a notice, even if there is a potential claim in the air, that's not a reason not to go do the work. In my view, I don't see that applies.
I just saw a question flash up of saying in a letter of claim or a letter before action, should reference be made to Awaab's law? And yes, completely if it applies, but carefully think through how it applies. And it's what we said before, that you want to be very clear that notice of this significant hazard was given on this day, and by X date, these steps hadn't been completed. I don't think it's enough just to say there's damp and mold and Awaab's law applies. And so, and there's also benefit in including Awaab's law, that if on the other side is a cautious landlord, they're much more likely to consider that Awaab's law does apply, even if there's an argument about it, and take remedial action as soon as possible, which is what it's intended to do. And that's the point that you were making, that this is all to make sure that a property is in repair and that there is no disrepair. And then if there needs to be proceedings on compensation and quantum after to quantify the loss, then so be it. But this is really about formalising the obligations on a landlord and ensure that repair works are carried out in timeframes that are strict.
Yeah, seen a couple come up about refusal of access. I think that comes under your reasonable endeavours. Obviously, again, you get disputes about the periods for disrepair and was it reasonable to refuse access? Was there an issue with the contractor or what was happening? But if there is attendance and it's unreasonable refusal, there is then obviously there's an issue there. I think obviously if you attend once, it can be hard. You can't just necessarily immediately attend the next day. Unreasonable refusal will help the defence, or will be a defence of taking all reasonable endeavours to address the breach. So if that is why the breach happens, well, that is a potential defence.
But so often I see access raised as an issue, and the court considers so many different circumstances, such as whether an individual was at work or they had other responsibilities away from the home. And that's quite often I find that sending a letter to say this is your appointment on 3 days' time, and it's not been communicated in other ways, isn't quite enough. And so if that's the defence, the landlord really needs to get to really think about how many appointments, how they're communicating with the tenant, how they can evidence the fact that access is an issue, rather than simply making a few appointments that for some reason haven't gone ahead. And if you delve down into it, the picture may not be so clear cut.
Yeah. Talking of not clear cut, I think this is a tricky question. I'm not going to skip over it because I think this will be a point. The question says it's been indicated that arguments around tenants' lifestyle creating damp and mold will not be as accepted as they once were. The defence of tenant causing breaches is, of course, still available. Are you able to provide any indication of when arguments around the tenant's lifestyle and choices causing the hazard are likely to receive sympathy or be rejected? I mean, that's going to swing from judge to judge, I'm afraid, is a point, because different judges will take those points differently. I think you've got to be mindful. My off-the-hip thought is you've got to be mindful of what type of conduct are you talking about. Is it obvious and sustained? And I have heard witnesses give evidence, even from a question from a judge of, I don't have to change my lifestyle, do I? Well, it depends what they're doing. And you see some cases of keeping tropical fish in open water tanks and there is significant damp in the property. Inspection is checked and it's no water ingress. It is purely from that issue. That's going to be, I think that's a defence.
And I think the crucial document there is going to be the investigation and the report that comes. And so if that's the defence relied upon, it needs to be a good investigation most likely having visited the property and setting out exactly what it is that the tenant is doing, such as keeping tropical fish. And that's the reason why. And I think without that, or if it's uncertain, it will be difficult to rely.
Yeah, I mean, I think the classic one of, I don't know, steam from the shower or something. I think the important thing to note there is it does, of course, again, it depends, which I know is not a helpful answer, but I think it's a rare case where steam from a shower is causing mold to the extent that it is this significant of a problem.
Yeah.
Because if it can build up over time, that's a different matter. But I think where you can perhaps have a Section 11 defence, and you're saying, well, it's a defect in design, so that's not just repair. That, of course, doesn't, as we already know, doesn't always help, won't help for an unfitness point. So I think maybe you made the analogy of the initial attendance for the wipe down and the wash down.
Yeah.
Later attendants might need to install trickle vents or ventilation or something. I think that's the way to approach it. I think, as the question notes, and as we've already gone over, conduct will still be a potential defence. But yeah, I think caution about that approach.
Yeah, and that's the spirit of the regulations.
All right, I think we're now coming right up to the hour. So thank you very much for everyone engaging there. I appreciate there are a lot of questions because it is evidently a very pressing matter, both for tenants, of course, living in these in conditions which aren't fit, but also for landlords complying with these regulations as they now must do. So of course that is reports from the 27th. And yeah, I mean, you've said you've already seen the pleadings coming in.
Yeah.
I haven't seen anything in pleading, of course, haven't seen it in court yet, but any day now, I'm sure it's going to start rolling through.
Exactly.
So if anything, of course, further arises, thank you so much for joining us. Any unanswered questions can be followed up by email. A reminder that if you are watching the recording, you have any questions, the questions are to events@42br.com, please. The recording will be available on the website and the YouTube channel as well. Please do go there to check out, and all our other webinars that have been covering very similar topics. And we will, of course, be very grateful for any feedback, guys. A form will go out with the slides, I believe, if you're on the mailing list for joining us live. So thank you very much. Again, I've been Max Gordon.
And Matthew Tim. Thank you very much for joining.
Thank you. Good afternoon.